Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asiedu Entry. Today we are looking at juvenile justice. Juvenile justice. The issue here is that in Ghana, our Act 29, that is the Criminal and Other Offences Act. I have the annotated version written by Professor Henrietta Mensah Bonsu, who is a Justice of the Supreme Court of Ghana. She wrote this mimicking or looking at the Act 29 of Ghana. The Act 29 technically deals with all criminal offenses against adults. And the point is, if you read Act 29, Section 26 of Act 29 will tell you that children below the ages of 12 are not liable for any criminal offense. We say they are duly incapable. The may partially says offer at 29. Now what can at 29 a criminal and other offenses actor. The can say a daily with crimes are yedeshe impedifo. But the name me perceive juvenile justice. And the point is, who is a juvenile becomes a critical question we will be asking. But before we proceed, we have a special guest over here to help us to understand this. He is a lawyer and a former district chief executive under the SWAO MPP administration at the Amansie South District. I have with me the Honorable Clement Opoku Jemfi Esquire, popularly known as Kwampoku CID Chief.
Yes,
Akwaba.
Yeah.
Member Akwaba to the Law Lab.
Yes, sir.
I could clearly see, sir, you are well prepared for this.
I hope so.
Good. And let me say, I am so much proud of you that as you became a lawyer, you've taken much interest in juvenile justice, because sometimes at DAC and it becomes difficult for us to understand the legal processes and others. But before we proceed, I would implore you to like, share, comment, and subscribe to the Law Lab YouTube channel. Tell a friend to tell a friend that lawyer Kwame Poku CID is here with us, and his interest as a lawyer is in juvenile justice. The point is, Bra Kwame, as I affectionately call you, the point here is that the law, when you pick at 29, that governs the crimes over here, in Ghana. Fortunately for us, it is an act, not a code, meaning we can find other criminal crimes in other acts. But the law of at 29, Section 26 is telling us the concept of duly incapable. Or see, within the 12 years, any person below 12 years is not criminally liable. That person does not have the mentis compos or the compos mentis, doesn't have the mental capacity. But you are also interested in juveniles. The point is, when you pick our constitution, the constitution speaks to a child being someone below 18 years. Interpretation Act is saying, I think similar. Oko contract law, or see, will be a minor only when the person is not 21 years. So, yeka juvenile, we want to clearly understand who is a juvenile.
Right. Thank you very much.
Not to interrupt you. Today we have the Act 29, we have the Juvenile Act to help us, and we have the Constitution, and also Bra Kwame has his iPad over here to help us. So who is a juvenile?
All right. Thank you for the opportunity. Like you rightly stated, I have so much interest in juvenile justice because I feel that at that age, you are too young to face criminal charges and be tried and, if possible, be sentenced. I mean, I feel so bad anytime I enter the courts and I see any juvenile who has come into conflict with the law. I feel it sometimes.
Even when the juvenile has committed a crime?
Yeah, no matter what, I still feel it, because what I say to myself all the time is that it could have been me. Okay. I did not been maybe grace or maybe good parenting. But what do we see these days? Some parents are so busy that they don't even know the lifestyle of their children.
Accra life.
Exactly. They come home late, wake up early as 4, back to work. It's a normal routine, then the cycle continues. So they don't even know their child so well. Okay. And so in an unlikely event that the child comes into conflict, either accidental or deliberately, then I feel for that child, because I keep saying it could have been me. The more reason why I have so much interest in juvenile justice.
So who then is a juvenile? We want to understand, because you are using child now, so we want you to maintain the juvenile.
Okay.
So that we know the distinction that if this person comes into conflict with the law, we know that that person is a juvenile.
All right. So this is a criminal procedure, and criminal procedure is so robust.
Okay.
It is so compact. If you cannot sidestep the laws,
Okay.
once the law says it should be A, B, C, you can never do A complement or B complement.
Okay.
You have to stick to it. So the juvenile justice procedure is it's governed by the Juvenile Justice Act 2003. Lawyers will mostly refer to as Act 653.
That suffices.
Yes.
Okay.
So moving forward, I'll just mention Act 653.
Okay.
The section that explains who a juvenile is, let me refer to my iPad here, my slides. Okay, so according to
bring it before you small.
No, that's fine. According to the Juvenile Justice Act here, that is Section 1. That defines, Section 1 defines who a juvenile is.
Okay.
You need to know who a juvenile is so that when there is any issue or someone comes into conflict with the law, you look at the age and say, this person is a juvenile, that person is not a juvenile. So Section 1 says that a juvenile is a person under 18 years who has come in conflict with the law.
Okay.
And that is what the Juvenile Justice Act is
saying. So if I get you, that person should be below the age of 18. If we are reading Section 1 of Act 653 together with Section 26 of Act 29, then it means that a juvenile is someone between 12 to 17 years.
Yes.
17 and 11 months, even the last day.
Yeah, 11 months, even 11 months, whatever days.
Thank you.
Still a juvenile.
So you are between, you are above 11 years, but below 18 years, technically.
Technically.
So, good.
And as at the time you committed the offense.
As of the time.
As of the time you committed the offense.
So even if you know, crime has no expiry date.
Yes.
So if you commit it when you were 15 years and you turn 22, we will still try you.
Yeah, we will try you.
Juvenile.
Yes, because at the time you committed the offense.
Okay.
You were a juvenile.
Okay.
Yes.
Okay. So
you know, criminal trial sometimes it takes so much a long time to arrive at a decision. So sometimes the person may be 15 years. Then you know, Ghana Police Service, they will arrest you back and forth, go on remand, do this, do that.
Your father is a police officer.
Before
so
my father was a police officer.
So retired police officer. So be careful.
Before the age could be even determined, the person might have been in police custody for like a year or more.
Okay.
I mean, this is normal because the ages will have the Attorney General's department may challenge the age of the juvenile, and then counsel for the juvenile will also say, I mean, my client is below the age of 18.
Okay.
So that back and forth will result to the judge giving orders to doctors to ascertain the age. So that process alone could delay.
I get it. So clearly we are dealing with juveniles and we are using the Juvenile Act. If we are going by the ordinarily the trial of persons who come in conflict with the law, it means that we are going to use Act 30 and go by the straight process. But because they are juveniles, we are separating them from the normal trial.
Exactly.
But you see, the point here is that in the normal trial, you know that the person will be arrested, will be arraigned before court, will go through the trial process, the person will be sentenced, convicted, placed behind bars, amongst others. The point is, the juvenile has committed a crime. My question is, who can arrest the juvenile? Because if I may end, if you pick Act 30 and you look at Section 10 and Section 12 of Act 30, it tells you that a police officer and also a private individual can arrest anyone committing a criminal offense. With regards to private individual, it gives some 5 circumstances, and police officer too, it gives the circumstances. But the point is, who can arrest a juvenile? Is it only police officers, or a private person can also arrest a juvenile?
Both. It follows so the juvenile justice system follows similar procedure as the adult justice as at 29. The difference here is that the juvenile justice is a bit softer, if I may put it that way.
Okay.
It is not too rigid and strict as the Act 29 would do. So a police officer can arrest a juvenile, and then a private person can also arrest a juvenile without a warrant.
Okay.
So the police officer can arrest a juvenile when the police officer sees, or in the presence of the police officer, the juvenile is committing an offense or a crime. Let's say, i.e., if the juvenile is holding a gun and maybe decides to point it at someone, the police officer can quickly arrest. The same applies to a private individual, or maybe you're causing damage to a public property or a property of the state. The police officer can arrest you, and a private person can also arrest you.
Okay. What of in a circumstance that let's say you are in a car as a juvenile and you drive past the highway, a police officer stops you. What if the police officer reasonably suspects that you have committed a crime? Can the police officer arrest you?
Yeah, the police officer can arrest you.
Okay.
Even a private individual can arrest you.
Even when you reasonably suspect?
Yes, but they can arrest you. The fact that, what traffic offenses are strict liability offenses.
Okay.
So when you say strict liability offenses, it tends, you will have to prove that you didn't commit that offense.
Okay.
You have like driving without a driver license. It's a strict liability offense.
Okay.
You will have to produce that driver license to show that indeed you didn't drive without a driver license. Immediately you drive your car without a driver license, you've committed an offense. Even when you're parking it, you've committed an offense. It's a strict liability offense. You stick to it. So reasonable suspicion alone, the police officer can arrest you. But the fact that he or she has arrested you doesn't make you the criminal. It will have to go through processes.
Another thing I want to appreciate is mostly when people commit a crime, let's say the person has killed someone or is destroying a public property. Certainly is destroying it with something. So if the person is an adult, be above 18 years or 18 and above, what the police officer will do is to search the person. The point I want to understand is, who can search? Can the juvenile be searched? Because he's a juvenile, a small boy. Watching and say he is committing a criminal offense, whether you reasonably suspect or not. 1, can you search him? 2, how do you search him? And 3, who can search him? Can a female search a male? You see, they will be putting their hands under their trousers and others.
Exactly.
Can a male search a police officer? A male police officer search a female, or a female search a male? I want to understand that.
It is answered in Section 10 of the Juvenile Justice Act 2003. Okay. So Section 10 basically governs who can search a juvenile upon arrest. So it simply means that a male will search a male, then a female will search a female.
So a female cannot search a male?
No, that will be an affront to the law.
But what if the male too has no problem? That the females will search a boys?
Privacy is very important. Privacy is very, very important. You cannot sidestep the law. I told you from the onset that criminal justice system, it's so rigid and strict.
Okay.
Any sidestepping will lead to the supposed offender going scot-free.
Okay, the acquittal of...
Yes, any sidestepping of that law. So prosecutors are always advised to stick to the strict provisions of the law.
So per your answer, then it answers the first question that a juvenile can be searched.
A juvenile can be searched.
In searching,
no, in fact, a juvenile must be searched.
Must be searched.
Yes, upon arrest.
Upon arresting, must be searched.
Yes, because they have to know whatever you have on you.
And 2, you are telling us that a male can only search a male.
And a female search a female.
My point is, a private person has arrested a juvenile. Taking the private person to police station, or say a police officer has arrested a juvenile. Now the person is below 18. You don't think it is proper the parent or the guardian should be around before you search him?
It is not entirely the case.
Okay.
The parent or the guardian will only come in when, after searching, and you want to say write statements, caution statements, what have you. But you have to, the law is that you will have to inform the parent or guardian of the juvenile upon arrest.
Okay, when it's arrested.
Yeah, as soon as possible. Okay. Or a lawyer.
Okay.
Everyone has a right to a counsel. So as quickly as practicable, once you arrest a juvenile, you have to ask the juvenile, who is your mother, who is your father, where do you live? Those questions. So once you ask, you have to quickly before even interrogating that juvenile, you have to inform the parent or guardian, and if possible, write to a counsel.
The point is, the juvenile, where does he get the counsel? Is it not from the parents?
Exactly. So once you inform the parents,
and they send
a counsel to come in.
So if I'm getting it clearly, would I say that it is only appropriate to interrogate or interview a juvenile only when there is a parent or
a guardian.
his guardian or counsel is around?
That is the position of the law.
Okay.
You cannot sidestep it.
Meaning you cannot interrogate a juvenile when there is no...
There should be an adult person there, not necessarily a police officer.
Okay.
Yes, so the parent or guardian should be there, or a lawyer.
So what of the three are not available? What happens?
It means you cannot interrogate. You can't.
Wow.
You can't.
But so what if that becomes a thing that the juvenile is deliberately saying to tell you that I don't have a parent, I don't have a guardian, so certainly I will not get a lawyer?
Okay, so
what then happens? So you should commit a crime.
No, you can't commit a crime and go scot-free. So what in practice, what mostly is done is they will ask any private person who is an adult to serve as the guardian, will be there. Then they will interrogate the person.
Even when the juvenile does not know the person?
No, but so in practice, what mostly they do is that they go to the district assemblies. There's an officer there who is captured as a probation officer.
Okay.
He virtually takes charge of the activities of any juvenile who has come into conflict with the law.
The social welfare people.
Yes, so you can say daytime they are social welfare, but when it comes to criminal justice, they are the probation officers.
Okay.
So the probation officer can stand in for the child.
What if the probation officer has a problem with the juvenile already? Maybe the family of the juvenile.
You should be professional enough.
Okay.
No, you should be professional enough. I mean, these are just preliminary interrogations. The matter will obviously go to the courts.
But my point is, the probation officer has an issue with the family of the child. Maybe before the mother or the parents died, he had quarreled with them. The juvenile got to know. Are we saying we can use any other officer in the assembly or?
No, the probation officer is the ideal person.
Okay.
And you see, what is his business there? His business is just come and observe.
But he has issue with the child.
You will have to come and observe. You are paid by the state to work.
Okay.
So your issues with the child does not come to play here.
But let's say the police officer would want to put out certain statement that will incriminate the juvenile. And the probation officer also does not like the juvenile. Maybe the juvenile is a notorious crime committer in the area. So what then happens?
You see, in normal criminal practice procedure, when you caution, the caution statement, the first caution statement can always be amended.
Okay.
It can always be amended.
So later when the juvenile gets a lawyer, he can raise it
always.
and amend it.
And it's even good when it happens that way, because we as lawyers, it helps us. Because you actually cautioned that the juvenile without a lawyer. And so it's a basis for us to amend the caution statement.
Right. So the next thing I want to ask is that mostly in a ordinary criminal justice system, it is from arrest, then you move to bail.
Yeah.
Either you grant the person a police inquiry bail, or a bail pending trial, or bail pending appeal. Meaning, bail pending appeal is far-fetched, the bail police inquiry bail or the bail pending trial is the most common. Police inquiry bail basically means that as the police is investigating the matter, they can grant bail. Yes, so meet mama, the juvenile on the bail. My point is, when you arrest a juvenile, is it compulsory, or is there an option for them to apply for bail?
Yeah. Once the juvenile is arrested, the juvenile has the right to bail.
Okay.
So at the police station, police inquiry bail and self-recognizance bail by the juvenile himself. When we say self-recognizance, like the juvenile himself will stand as a surety.
He doesn't need any surety.
He doesn't need anyone. Unless, so the law is that unless it's a serious offense, that's the police saying that the juvenile alone himself cannot be granted bail, then the parent will have to come and stand as sureties for the juvenile.
Okay. But, so ordinarily the juvenile himself can acquire the bail.
Yes.
Okay.
It's a soft life sort of, like they will allow you, because it's a juvenile justice system we are running. They always want to mitigate the situation or the processes for the juvenile. It will not be as rigid and as strict as Act 29 would have envisaged, but in the Act 653, it is a bit liberal.
So the next thing is that you mentioned that on serious offenses or serious crimes, the police may not grant the bail.
Yeah, they may
so
not.
The point is, now the person is a juvenile. Should we put him in the male cells, or the adult cells, or the female adult cells? Is it permissible like that?
It is not permissible. The position of the law is that juveniles must be separated or kept separately from adults.
Okay, I thought that should be in the prison, but normal police
station. Even in the police station. So if you don't have a juvenile cell available, so let me cite an example. During my time as a district chief executive, I put up a police station, and I ensured that we created 3 separate cells, one for male, one for female, and one for juvenile.
So the juveniles, you put both the male and females in one cell?
Ordinarily, juveniles, they don't commit the offenses as frequent as normal adults would do.
But ordinarily, it should be male and female.
Yes, it should be male and female, but so you separate them.
Okay.
But at least if you have one, it is better than none.
Okay.
But in the absence of any...
You are purging yourself.
No, in the absence of any...
You should have made it 4.
Anyway, in the absence of any, then the police is obliged to either hand over that juvenile to the probation officer.
That is a social welfare
officer.
For him to take him...
For him to take him home.
Okay.
Then bring him maybe the next day. Or any police officer, either male or female, depending on the sex of the juvenile.
Okay.
But the probation officer, it doesn't matter his sex, his or her sex.
Okay.
That's the difference.
I see. Now, what I want to understand is that, you see, after bail, the next thing is that we are going to court. We are giving special rules for juveniles. I want to understand whether, with regards to juveniles too, we are going through the normal court system where the judge is at the bench. In front of the judge is the clerks. On the right side of the judge is the criminal, the dock for putting people who have been accused of criminal matters. Left side, witness box. Then we have the well. And after the well, having the bar over there with the lawyers and also the audience or those who come to watch the court. Okay. Is it a normal court sitting we are dealing with?
It is not the normal court sitting.
Okay.
So, under criminal justice system, it is an informal sitting. Okay. Just as we are seated here.
Constituted by which people?
The judge. Then the clerks will be there. Police, any other person. But the normal court attendees, if you are not a close relative to the juvenile or a parent or guardian to the juvenile, you are not allowed in the courts.
Okay, so the court can restrict the...
Yes, number. When it comes to juvenile justice.
But does it happen in the main court or in the chamber of the judge?
So if the judge wants to do it in the open courts, then the judge will have to restrict entry. Then it will be just close family circles. Then police officers there will not even be in their uniforms. That is the position of the law. Police officers should be in normal mufti, normal civilian uniforms. The judge will not necessarily have to even robe. Lawyers will not even robe. I mean, it's a flexible setting, an informal one. They don't want the child to entertain any fear. You are in court, you fear, you see police officers. Sometimes police officers come to court with ammunition, arms, and yes. So they want to take that out. And in all cases, or let me say in most cases, because there are exceptions, in most cases, the district courts are the designated courts for juvenile justice.
Okay.
And so they are the juvenile courts.
Okay, the district court.
The district courts are the juvenile courts, except that if there is no district court, that is the exception, then the law is that any court with a summary jurisdiction.
Okay, so summary jurisdiction meaning those who have the authority or the jurisdiction to hear offences which punishment does not go beyond 6 months or a statute has prescribed that they should have a summary jurisdiction. Okay,
so
like the circuit
court, high court.
Okay,
so even after that, you have to, after the whole trial, you have to send the juvenile back to a district court for sentence. I know you come there. So that is.
No, you hit on that for me, because so you mean that even with regards to the district court being the exclusive original, has the exclusive original jurisdiction to look into juvenile matters.
Yeah.
When it comes to the exception, which can be, let's say, if you pick an area like Brahabebome or Mehame, your own friend at PCFM, what is his name?
Nanaya
Okesi. Maybe there is no district court in Nanaya Okesi's district. I think I'm saying this for Odia and trying to slash him. So, if there is no district court in Mehame and there is a high court in Goso, meaning the high court in Goso can try the matter.
Yeah.
But when they, after hearing the matter, they now need to find a district court nearby and transfer the case to the said district court for that district court to pass sentence on it.
Exactly. That is the position of the law.
Wow.
And so that it is called remission.
Okay.
You remit back, you remit the juvenile back to the juvenile courts for sentencing. And even in situations where maybe an offense is committed by a group of people, inclusive of the juvenile, they will all be maybe the adults. I mean, adults committing offense with a juvenile. Let me explain it to you. Adults committing an offense with a juvenile. All of them will be tried at the high courts,
or the
circuit courts. All of them, including the juvenile. However, the juvenile alone will be remitted back to the juvenile court for sentencing.
Okay.
But the rest will be sentenced at the high courts.
Let me tell you this story. There were some 4 gentlemen with 1 juvenile being part. They went to steal a goat. And when they stole the goat, when they were sharing the meat, they started putting the intestine to one side. And when a young boy, and they said, the juvenile said, this one there, the Obenya Ketuano, Obako come. So in that case, if he goes to say it and they are caught that they've stolen a goat, they will try all of them maybe in the circuit or the high court. However, we shall remit only the juvenile court for
sentencing. The sentencing, the maximum it can go is 2 years.
I'll come back to the sentencing. The next thing I would want to appreciate very well is that now the work of the Attorney General's department, the prosecutors, is to get rid of crimes or criminals in our society. They want our system to be very free. Now the person comes out. You as a private lawyer, your duty is to be defending the accused and others. You would always want to push the young boy or the person, your accused person, to be a juvenile because you don't want the sentence to go beyond 2 years.
That is not the case.
I'm just giving a hypothetical situation.
Anyway.
Now, the AG too wants to punish the person because what he's done is very dangerous. And so the AG is saying that this gentleman is above 18 years or 18 and above. And the lawyer is also saying that the person is a juvenile. So in that case, how do these two, what best way would the court come to a determination that to prove the age of the juvenile? How would the court come to a determination to prove the age of the juvenile?
So the position of the law is that where there is a conflict or an argument or a confusion as to whether the accused is a juvenile or not, mostly it happens because I handle a case like that where the AGs were of the view that the accused was, I think they said it was 20 years or so. Yeah, I remember 20 years. But my client, the accused, had told me that he was just 17 years. And so the issue for determination was whether or not the accused was a juvenile. So I raised the point that we need to ascertain the age of the juvenile. However, unfortunately, the position of the law is that the age could be ascertained by the birth certificate of the juvenile or the baptismal certificate, or a certificate signed by a medical doctor.
Okay.
A medical practitioner can determine the age of the juvenile if the birth cert or the baptismal certificate.
Now Ghana card is in.
So now, but the time they were
Passed the juvenile.
yes, when
That
this
was
act went to
2003.
Parliament, the Ghana card was not in motion. So I'm sure with the Ghana card in the system now, judges may make those orders. So my client didn't have a Ghana card, he didn't have a baptismal certificate. So the AGs had to, at a point, tender in evidence the voter ID card of the accused. I told the court, in fact, I vehemently objected to it, that it is not provided for in the law. However, looking at how polarized our political system and political landscape is, anybody who is seeking power can just mobilize a group of people who are below the age of 18 to go and register and vote for. It happens. I mean, this is a rare situation. Looking at the boy, he's less than 20 years as they claim. So the judge made orders that he should be taken to Konfo Teaching Hospital for dental re-examination on the teeth to identify whether indeed. So mostly that is what they do. Either you do an MRI scan or you do dental medical examination to ascertain the age. And once that certificate is signed by a medical doctor, the court will hold that to determine the age of the juvenile.
Okay. So another thing I would want to understand is that, you see, you go past arrest, you come in bail, you bring the person to court. Now, in criminal trials, the most important stage is taking of plea, where the person pleads either guilty or not guilty, or guilty with explanation, all those things. In juvenile justice, since the person is a young person, do you still take a plea?
Yeah. It's a basic rule. It's fundamental. You cannot sidestep it. So you take a plea, whether you are guilty or not, and it should be explained in the language that the juvenile understands.
Okay.
Yes, if that language, I remember I witnessed a case in court that the accused said the only language he could speak was Kasana, Upper East.
Okay.
And they didn't have a court interpreter who could interpret. So they had to stand.
But you are from Upper East.
But
are you from Upper East or West?
Upper East.
So you don't speak
Ashanti and
Kasana?
Upper East.
Okay.
Yes, so...
You don't speak Kasana?
No, I don't speak.
But what do you speak?
I speak Frafra.
Frafra.
Yeah.
So you are Frafra?
Yeah.
One book CID, you are Frafra?
Yeah, Frafra and Ashanti. So,
oh, I get it.
Ashanti Frafra.
So you are also called Awuni?
Yeah, of course.
Okay.
Yeah.
I see. I get it. So you didn't get anyone who speak the Kasana?
Yeah, so they had to stand the matter, adjourn it, and the registrar was tasked to ensure that they get someone, an independent person to do that.
To maybe go for someone at the School of Language.
Exactly.
Mostly
that is best.
Now, what I want to understand is that, so the person will certainly take a plea.
You take a plea.
Whether you are guilty or not
guilty.
The next thing I want to understand is that, you see, we have 2 types or 3 types of bail. Police inquiry, bail pending trial, or bail pending appeal. But in this instance, you've already talked about the police inquiry bail. Granted, the police feel that the matter is a serious offense. They didn't grant him bail. The person appears before court. Can the juvenile seek for bail pending trial? And can the court refuse that bail too?
Yes, the juvenile is entitled to bail at any point. By Martin Pegbu versus Aegis.
Yes,
every offense is bailable.
Yes. But it is subject to the discretion of the court.
I mean, it is bailable, but it's at the bosom.
Okay.
We are in the hands of the judge. So whatever he or she says is final.
Okay.
So the juvenile is entitled to bail. However, the court may refuse the bail. But in this instance, you will have to give reasons to why you are refusing the bail. So the fact that the law is saying that the judge should give reasons for the refusal of the bail should tell you that bail for a juvenile is constant in courts. But if in an exceptional case you decide to refuse the bail, then you're obliged to give reason for your refusal.
Okay.
That is the position of the law. And let me add that if it is determined that the juvenile is indeed a juvenile, the accused is indeed a juvenile, per the records available, then the sentencing is passed. Then the juvenile begins to go through the sentence. There's a sentence. And then it is later found that it's like they tricked the courts. The person indeed was above 17 years or was even 20-something years.
It was not a juvenile.
It was not a juvenile. The position of the law is that it will not affect the earlier sentence.
Okay.
It will still stand.
So if you're able to convince the court that you are a juvenile whilst you are not, and we pass the sentence, and later it comes out that you are not a juvenile, still that sentence would still be
it will still stand.
Okay.
It will still stand.
Okay.
Because when it happens, it can be said, fontis of issue.
Okay.
The judge is done with his job, so
okay.
There's nothing you can do.
Okay.
Yeah.
Bra Kwame, thank you. I think I would want us to end here. And in our next episode, we will be looking at the trial of the juvenile proper and go through it and go through the sentence and what goes into it. So thank you very much for showing up on the law.
The pleasure is always mine.
We are hoping to host you the second time for us to go through the trial itself. So thank you, ladies and gentlemen. This has been Clement Opoku Jenfi, who today we all know is also a frafra. So he's an Ashanti and a frafra. So he has his name Awuni. He needs to explain to us in the next episode what the meaning of Awuni is. But he is taking us through juvenile justice, and we have appreciated who is a juvenile. We understand who can even arrest a juvenile, gone through that the juvenile can be searched, and all these things to the extent of even when we can determine the age of the juvenile amongst others. He's giving us the legal ramifications about it. In our next episode with Kwame Poku CID, we will enter into the trial of a juvenile and to know whether the court does something very special in ascertaining the trial amongst others. And also, we would actually delve deep into juvenile justice as we've done in this episode. Thank you very much. Don't forget to like, share, subscribe, and tell a friend to tell another friend that this is the Law Lab. And remember that this episode is proudly sponsored by Nkrumah. Nkrumah does all assorted food. Myself, I'm even questioning why they call themselves Nkrumah as they are at large or with regards to culinary activities. Thank you very much, and this has been the Law Lab.